Yes, a very warm welcome to this knowledge session of the China Knowledge Network. A quick explanation about myself. Perhaps it's not visible on camera. Hopefully it's from the waist up, but from the waist down. I have, for the people in the room, a torn Achilles heel, which means that from the waist down, I look like a cross between, I decided it was a one-legged pirate and Robocop, something like that. But from the waist up, everything functions very well. So with that, hoping to draw too much attention to that, I would like to ask your attention for the theme of today, which is the rule of law. As I said, this is part of the China Knowledge Network, knowledge sessions. And
the
China
rule
Knowledge
of law
Network
in China?
Rather unique collaboration.
Government
of the
accountability.
Klingendaal and Asia Center with all government ministries and
van
people in
Universiteit
the,
Utrecht.
let's say, knowledge realm of the Netherlands. So that's the flag under which this session is being held. It's perhaps good to mention that this is the first 2025, and from 2025 we want to do a knowledge session every month. And on a fixed time and date or day in the month, every second Tuesday between 9 and 10, we will have a session like this, touching on topics that hopefully explain China a little bit better. The format and the rules of the game are always the same. It's a hybrid meeting, so people are in the room but also online. Warm welcome to you. It's being recorded. At least the keynote part of the session. Perhaps also good to mention that it's Chatham House rule, as always. So we will start with the presentation in a minute of about 20-25 minutes by our keynote speaker. Today we are also happy to have a discussant who will respond to that. And then the second half hour of the meeting will be opened. We will open the floor for Q&A, and then at 10 o'clock, everything will be wrapped up again. Again, this is a session about the rule of law, specifically about the interaction between the government and civilians in the court of law, let's say. But the discussant also has a lot of expertise on company to government and state-owned enterprises to the state and how they interact in the courtroom. So allow me please to introduce our keynote speaker. If you could step forward, and meanwhile I will explain that you studied law at Beijing University, then worked in a number of places, did your PhD in Utrecht and taught at the VU in Amsterdam. And now you are the founder and director of Law for Sustainability. So again, a very warm welcome to you, please. You're going too fast. Sorry. There we go. This started here. So please.
Yeah.
We will put the presentation full screen online as well, so people at home can attend or can see what the slides are about.
Yeah. Okay. Well, thank you very much for your introduction, and of course, this excellent opportunity for me to extend my research output with everyone here and also online today. To start with, I'd like to invite everyone to make either your smart device or computer ready, because we are going to play a little game together. True or false? If you are with your mobile phone, you can simply switch on your camera and scan the QR code on your right. If you are on your computer, you can go to the website nati.com and then enter the code below. Feel free to raise your hand or give me a shout if you have any difficulty connecting yourself. Are we all on the same page? Yeah. We often assume that we know quite a bit about China, Chinese politics, or the Chinese legal system. What I'm trying to test you here today is to see whether certain facts may still come as a surprise. Ready? Let's go. Yep. Which statement below, in your view, is false? 1. Not every judge in China graduated from law school. 2. China didn't have the national bar exam until 2002. 3. China recognized the equal protection of private property in 2007. So you can simply give the answer that you deem as false.
So which one is false, right? To be clear.
Which one is false?
Yeah, okay.
I see some answers already coming. Yes, it seems the majority is still challenging. Believes that the third statement is not true. That is, China recognized the equal protection of private property, not in the year 2007. Some might think it's earlier, some might think it's later. Is there anyone who believes all of the statements are true? Well, what's the correct answer? All of them are true. Surprising, isn't it? The Chinese legal system, even to a Chinese, is often coming as a fascinating paradox. As we have seen from the statements earlier, on the one hand, there has been institutional delay, or rather unwillingness, if you wish, to train legal professionals for protecting the fundamental rights of natural and legal persons. On the other hand, recent decades have witnessed significant reforms within Chinese legislature and the judiciary, which we will see in a second. The book that I published last year is an attempt to answer a very basic question. Is the law truly taken seriously in China? This book reflects my academic growth, mainly in this country. A journey that took me from taking law as a kind of self-standing institution to seeing law as a part of a much broader cultural construct. And I assume in your life, there must be certain moments that are so shocking that left you no choice but to wrestle with deeper questions. And for me personally, that shock moment came in 2014, the very first year for me to be in this country. Florence had already learned about this story. In that year, I was waiting for a Dutch friend to come at Utrecht Central. Arriving a bit late, he apologized, saying, I just ran into the mayor of Utrecht on my way here. We had a little bit of chat. Surprised, perhaps even shocked, I asked him, what do you mean by ran into mayor? Does he just walk in the street like everyone else? And he chuckled, replying, yes, of course, even our prime minister rides the bike in the street every day. This shock moment was such an eye-opening experience for me, coming from China, where public officials, especially at the senior level, always carry this aura of surveillance and formality. The idea of encountering a mayor and even having a casual chat just felt surreal. In the years to come, when researching on government-citizen disputes in different cultures, I have always reminded myself of this shock moment in Utrecht. It's not just about accessibility of public officials in different cultures. It is about something more profound, how authority and normancy are deeply embedded in a culture.
Let me just allow, because you kindly took the book with you, give us presents, so thank you very much. But I'll pass it around. So
perfect. Yeah. Thank you, Flores. And my book starts with a very simple question: how different is China from its Western counterparts in the area of government accountability law? I looked for answers in mainly English and Chinese language research literature, and have concluded that China is indeed different given its old tradition of governance accountability. What it means? Under the principle which I summarized as substantive reciprocity, the ruling class in China were deemed unchallengeable by ordinary people on the condition that they were competent to govern the society well. However, if they failed to do so, then it was considered rightful for ordinary people, or 100 names 百姓 in Chinese, to go rebelling against the ruling class. This is the defining element of understanding government-citizen interactions, disputes, even in contemporary day China. On the other hand, I don't really agree with a very popular theory that Chinese governance practices and the legal system in China should be assessed on its own terms, given the modernization of the Chinese legal system in the 20th century. I will share with you some of the most far-reaching moments in this modernization phase. The introduction of government accountability rule during the Republican era was heavily influenced by the administrative court practices in the US and Japan in the first 4 decades of 20th century. And later, of course, under the revolutionary era, the local implementation of the so-called mass lie doctrine, under which political powers had the supremacy over Chinese legislative and judicial powers, was heavily influenced by the governance practices of the former Soviet Union between 40s and 70s. What is more relevant to today's sharing is what Chinese scholars summarize as the legal renaissance in China from late 70s to present day, where administrative justice theories from Europe played a major role. To conclude, any attempt to differentiate what is essentially Chinese from what is not Chinese is simply empirically impossible. And this is the stage on which we can understand the case studies of my book. If you are interested in the history of Chinese governance legal modernization, you may be interested in reading chapter 2 in my book. But about case studies, in chapter 5, it's about rural protests, chapter 4, labor actions, and chapter 3, collective petitions, which will be the case sharing for today because it closely relates to the long-standing tension between politically guided decision-making and law-based decision-making in dealing with citizen complaints against government conduct in contemporary China. My analytical assumption is that to take administrative accountability law seriously in China, we have to look at not only the changes at the legislative and regulatory levels, but also changes to how those rules and agency conducts are perceived and discussed on the broader public discursive level. To that end, I have analyzed 47 formal documents, including government regulations, political resolutions, and court decisions and opinions released between 1957 and 2022. I have also analyzed more than 2,700 news reports released by the Chinese news media between 1998 and 2015. The procedure for receiving and reviewing petitions brought by ordinary people is a long-standing element in the indigenous Chinese governance tradition. In the late 70s, China reinstituted this procedure as alternative to the then dysfunctional court system to deal with millions of wrongful charges and mistreatments during the Cultural Revolution. And that procedure had remained a popular choice. The citizens had complaints against the government until the early 2000s. Before that, the Chinese courts simply didn't have the power to be trusted as an impartial adjudicator in the eyes of ordinary Chinese people. And of course, that has changed over the first decade in this century. A major change came in 2005 when the national regulation on managing petitions was substantively amended. And in particular, petition handlers no longer had the power to act as some quasi-judicial agency to adjudicate complaints brought by petitioners. And they no longer had the power to disperse the petitioners with the help from the police force. Later, in 2007, China adopted the national regulation on the disclosure of government information. What's its application for petition handlers? Previously, the political guidance, or what is called 领导批示 in Chinese, was a powerful tool to have petition cases concluded. But of course, that political guidance was usually obtained behind the doors. After the national regulation on the disclosure of government information, petition handlers legally can no longer do that because any records leading to the settlement of collective petitions needs to be disclosed to the parties concerned and also the general public at their request. On the one hand, the legal regulation and legal accountability are more relevant to the settlement of collective petitions after 2007. On the other hand, the life of petition handlers is getting very hard. They are still part of the administrative regime, meaning they have to be accountable to their political superiors, and their agenda is always about political sustainability. And how can they reconcile the tension or sometimes even conflict between political and legal accountabilities? That is always a big question mark for the agencies on the ground. And in 2008, the central government passed this disciplinary penalty law that is applicable to the settlement of major petition cases. Any failure of the petition handlers to consider and respond to collective anger, and that failure leads to a collective protest, would subject the responsible petition handler to disciplinary, even criminal penalties. So after learning some of the major reforms at the regulatory and the implementation levels, how this legal accountability really socialized in China. I look at the news data through three dimensions. First, I look at how diverse the news sources are. And roughly before 2010, the news media's, their narratives mainly base their narratives on the official sources, mainly from the government statements and press release. But there's a very visible change after 2010, where the news reports present not only official statements, but also court decisions and academic inputs in their reporting. What is more interesting is the change of their narrative focus. In the earlier news, the focus is always on what has gone wrong with the collective petitioners. And the current descriptions include abnormal, disturbing, and unreasonable. And based on that narrative, government reaction to monitor and even to prevent collective petitions is narrated as reasonable. In contrast, more recent news focused on what has gone wrong with the settlement procedure. Is it efficient? Is it effective in addressing the losses and grievances of the petitioners? In other words, there is a very interesting change across time to the Chinese news narratives on collective petitions and petitioners. And the change is from order-focused to settlement-focused. I also look at how Chinese news portrays the major actors involved in the settlement of collective petitions, including senior officials, judges, and community advisors. And across time, just taking the news narratives of senior officials as example, the previous focus is about whether the political intervention has been helpful in sustaining the confidence, the trust of petitioners in the local government. And that trust focus narrative has gradually transitioned towards the results, whether the political intervention is really playing a positive role in concluding petitioned matters. And instead of portraying political intervention as a reasonable element, the more recent news is more diverse in framing the political intervention. It also refers to some problematic implications. For instance, how the political guidance really complicates the promotion of law-based review procedures. In a nutshell, the narratives have changed from confidence-centered towards remedy-centered. To conclude, on the case study of collective petitions, the long-standing conflict between political and legal accountabilities of petition settlers has been changing with the rise of the relevance of legal accountability and the decline of political accountability. That doesn't mean that political accountability has been replaced by the latter, but there's a changing dynamics between the two. And that is relatively clear at the rulemaking or rather rule-changing level. But if we look at the front-end implementation cases, the petition handlers are actually very stressed by this existence of dual duties. They have to be efficient in addressing collective petition cases. On the one hand, they have to make sure the conclusion will have a kind of positive social impact on the stability and also the trust of the petitioners in the government. On the broader discursive level, the news stories around the collective petitioners have been also promoting these relevant narratives, and the stability-centered narrative is on a decline. And similar trends can be also observed in the other case studies. If you are interested, I'm more than happy to discuss with you in a bit more detail. But taken as a whole, I conclude with this term, challenge the juridification, in my book. To summarize the major findings, China has been taken as having only law with no rule of law, which is divorced from reality, as demonstrated in my book from the perspective of government accountability law, and also public attitudes and the general discourse around how government should behave have been undergoing this very interesting change as well. And next steps, I want to test the validity of my theoretical framework in other two very exciting topics. I met a group of senior judges from Estonia and Hungary in 2023, and I realized the attitudes, internal attitudes and public attitudes towards court judges are very different between, let's say, those states under the Soviet Union influence and the traditionally liberal states like Netherlands or the regions of England. And the results for adopting automation tools in assisting judges making decisions is quite contrast. In the regions like Estonia, they didn't assume judge to be trustworthy. And additional to that, they have a certain preference for judges who studied in the West. And that is the exactly same case in China. And without taking judges to be impartial or trustworthy in the first place. Automated tools really have a different institutional and public support in their broad application. So I want to study this topic from a comparative and empirical perspectives. That's one thing. Another topic I want to develop further with Wang Yang is the corporate social responsibility, especially the legal duties of promoting ESG impacts in EU and China. And I want to see within this topic how government intervention is perceived by companies who want to do business in EU or Chinese companies who want to do business, European companies who want to do business in China. If you have any funding or research interest, please do reach out and let's have a follow-up chat. I thank you for your attention and look forward to our discussion.
Thank you very much for shining some light on the rule of law in China, where private citizens are involved mainly. Now I'd like to invite Wang Yang to respond. Just a quick introduction. Mr. Wang has studied at Renmin University and Harvard and also University of Amsterdam, but also worked in Beijing working for Minmetals, the Chinese state-owned enterprise, and then worked in asset management. So the question is, what happens? So this is private citizens against the state, let's say. Now see what happens when state-owned enterprises or big sort of private companies don't see eye to eye with the government. So
Thank you, Boris, and thank you for having me. As Boris just introduced, I don't have a legal background, but I'm more shed light from a political economy and finance perspective. So I would like to start to introduce about my concept or recognition of Chinese rule of law from the religion. I think before from the West to have a monotheism, so only one God. But in China, we have multiple gods. So if you want to get rich, you go to Cai. If you want to get a good harvest, you go to another god. If you want to have a baby, you go to a third god. So that I think the idea of towards law in China is quite different from the West. In West, there's a general respect or even revere about the concept of absolute. That is the goal. That is the law. But in China, it's about expediency. So which particular need you have and which god go. And that actually explains how the Chinese rule of law evolves. It's basically start from the market economy and the need to resolve conflict between different stakeholders. As you probably have well known that although China is like a single unified country, but there are multiple provincial government, and there are also even the municipality, even within the state-owned sector. Because I previously worked in a state-owned enterprise, it is under the central government SASAC was the way. So it's different from a state-owned enterprise of a provincial level and from a municipality level. So if in the case of what I experienced, my company has a conflict with Bank of China, that's another financial institutions under the central jurisdiction that can be resolved by political maneuver, can be through the reconciliation from, for example, a vice premier and step into and solve that conflict. But in the case of when a central SOE have a conflict with a provincial SOE, that cannot be simply dealing with dealt by the political means and only by legal means. One of the recent case we discovered this January occurs. For example, it is a case where a SOE in Sichuan invest in a trust product, which is issued by Zhongxie Xintuo, is a central financial institution under the central jurisdiction. And that money goes eventually to a municipality level in Guizhou, which default. So essentially, it's one state-owned sector through a financial intermediary to a municipality entity of another province. And that goes through the legal procedure and was accepted by the Chuanyu Jinrong Fating, which is a particular financial court under the Sichuan and Chongqing area. So that in that case is only through the legal means. So my point is that the Chinese concept of rule of law is not that absolute, but it really evolves by the economic needs and particular circumstances. And also you can view from that in the recent evolving of the government attitude toward private capital. 5 years ago, there is a lot of backlashing against the private capital. And now, as the economy weakens, there's another movement to legislature on the promoting private entity and also encouraging foreign investment, as you can see from the visa-free policy for the most European Union countries. So my point is the Chinese rule of law is not really a static or even not a linear progression. It's really a circumstance depending case.